Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County, courtroom 304. This is the criminal motions calendar for August 19, 2024. I'm going to call the calendar for the attorneys who are representing these defendants. Please go ahead and make your announcement. First case on the calendar is Archie, Kiera Simone Archie, Julie Kurt.
And good morning, Your Honor. The state is ready to proceed forward on this motion to revoke bond.
I know the last time we were here, Ms. Kurt had a leave, but it's my understanding that she does not have one currently.
Correct.
All right. Has anyone heard from her?
No, Your Honor, I have not. Is her client on?
Your Honor, the attorney's in the courtroom.
Oh, okay. Come on up, Ms. Kurt.
Miss Archie's here, Judge. Where do I need to
Just
be somewhere where y'all?
Yes.
Sorry. Maybe
Yeah. There you go. Just there's the camera.
Here I am, Judge.
Hi.
How are you? Good morning.
Good morning.
Judge, my client's here in the courtroom, Judge. Could we have a pretrial?
Sure. Give me a minute and I'll give you an opportunity to speak with Miss Hagler.
Would it be easier if Ms. Hagler called me, or should I log into the Zoom and maybe you could put us in a breakout room? What's easiest for the court?
Or I could walk down there.
Ms. Hagler, go ahead.
Or I could walk down there.
Oh,
Okay. So let me call the calendar and then she can walk down there and there may be some
Great.
other people that she can address while she's there.
Good to see you.
All right.
Thank you,
Thank
Judge.
you.
All right. Javon Eric Barnett. Javon Eric Barnett.
Good morning, Your Honor. This is Zakia Watson Cote. How are you? Sorry, Your Honor. I had filed a withdrawal of the not from the case from our motion, so we don't intend to move forward on our motion this morning.
All right, so that motion is withdrawn.
Yes.
And you all are still ready for to go forward on a trial?
Yes.
All right, then you'll have notice of your trial date. Thank you.
Thank you, Your Honor.
Judge, the defendant does have an open case, just for the attorney's attention.
Other than this one?
Yes, we have an open case. And we would like to have that case arraigned today if the defendant is present, but he does have an open case.
All right.
I'm sorry, Your Honor, I didn't mean to interrupt.
No, go ahead.
I had withdrawn the motion, so I didn't have him log on. I can call him if Your Honor requires, or we could file a waiver of the arraignment.
If you want, well, do you know what the case is about?
I don't. I need to talk to the state, but I can talk. So no.
Okay, so if you want to do a blind waiver, I mean, that's up to you because you can always talk to the state and I guess resolve it. But if you want to do that, I'll accept it. That's fine.
Okay.
So waiver of arraignment on the second case.
Yes, Your Honor.
Thank you, Judge.
All right. Thank you for bringing that to my attention, Ms. Hagler. All right. Ms. Watson Cafe, you're free to go at this time. Thank you.
Thank you, Your Honor.
Kirby Lee Hall.
Your Honor, the defense counsel did submit a conflict. Your office should have received it, but he did submit a conflict.
Yes, my conflict cleared up, so I am present in the courtroom this morning.
Oh, okay. All right, so for the motion for Jackson Deno and motions to suppress, are we ready to go forward on those?
I was actually going to be asking for a continuance on that, Your Honor. I'm supposed to pick up the video today from the solicitor's office. They gave me the written discovery about 10 days ago, but I'd like to get that video and review it so I can particularize my motions.
Okay, anything from the state?
Your Honor, we're not going to object. That's fine.
All right, so we'll continue this. This will be continued. It may be continued to pre-trial, I mean, to right before we have the trial. But we'll give you notice of whatever, when we're going to reschedule it.
Thank you, Judge. That concludes my business. May me and my client who's on Zoom be excused.
Yes. All right. You're free to go, Mr. Hall. Thank you.
Video, thanks.
Okay. Andy Amir Jiraim. This is James Dalton's case.
Good morning, Your Honor.
Oh, hey, Mr. Dalton, good morning. So, what's, or your announcement on the motion to dismiss?
What's the state's announcement, Your Honor?
We can pre-try that, Your Honor, to get a little more information. We can pre-try that with defense counsel.
All right, so she intends to walk down to the, courtroom in a few moments, and she'll speak with you then.
That would be fine. Thank you very much, Your Honor.
All right, thank you. You'll see Johnson, Lister Holton Dennis.
Good morning, Your Honor. I
Good
just
morning.
asked to pre-trial that with Ms. Hagler, attorney.
All right, so she can talk to all of y'all when she comes down. Deshaun,
Rashid Miles, that's mine as well, Your Honor.
Uh-huh.
This time I'd asked to continue that. I was having difficulty reaching out to my client. Apparently his phone number had changed. And that's something that we could probably have just a motion in limine prior to trial.
Well, Your Honor, if the defendant received notice, we will ask for a bench warrant.
This is our motion. He isn't required to be here, so I don't think a bench warrant is appropriate.
yeah, I don't care so much about the bench warrant as much as I care about, but it's a lot. You can't reach him?
I wasn't able to reach him this weekend. That's correct, Your Honor. I did not have an updated phone number. I'm going to check to see if he's updated it with the clerk of court and reach out to him. So I just asked her to continue. If we can't continue, I'll withdraw the motion at this time.
All right, it's probably best if you withdraw the motion. If we want to refile it as a motion in limine pre-trial, that's fine.
Thank you, Your Honor.
All right. Edwina Chukwuma Okafor. Okay, this case was closed. The motion was for new trial with Attorney Toombs. Mr. Toombs, you want a motion for new trial?
Yes, Your Honor.
Okay. What's going on?
In this particular case, Your Honor, Mr. Okafor, he came to court and there was a video. The police officer had stated to him that there was a video and no one never produced the video. He says all he wanted to see was the video because he stopped at the stop sign. And he asked him for a new trial and asked, and we would like to have some discovery where we can see this video. So all he wanted to do was see the video because the officer said he had stopped and, but he didn't stop for 3 seconds. And she said she had it on video. This is all he wanted to see was the video because he stopped.
Okay, the request, so the issue, Mr. Toombs, is did he make a request for the discovery?
I didn't represent him at trial, Your Honor. He represented himself. But we asked in the interest of justice that he be given a new trial.
In the state?
Your Honor, at this time, we ask that you deny defense motion for new trial. Number one, the issue is now moot. After speaking with Officer Richards, that video has not expired due to the retention timeline, so it's no longer available. She can't get it, we can't get it. And number two, Your Honor, like you touched on earlier, the defendant was told by Officer Richards to file an open records so that he can get a copy of that video. The defendant failed to comply, failed to follow Officer Richards' guidance, and so for those two reasons, we do ask that you deny defense's motion.
Well, Your Honor, he asked for the video over and over. He has a real
okay. Asking for it and putting it in writing is two different things, Mr. Toombs. And we know organizations like writing. Did he put anything in writing requesting this video?
Not that I'm aware of. He didn't know to do that, but he asked for it at trial. He requested it. He mentioned it. And no one never, listened to him or mentioned anything about the video that the officer said she had. She had him on video. So it's all he wanted to see was the video. So we asked that the court set aside the judgment and reopen this case.
Okay, well, with the representation from Ms. Hagler, the video no longer exists, so there's no grounds for the court to overturn what's been done. Mr. Okafor didn't pursue the discovery. He didn't pursue it from the solicitor's office or the police officer. even though he was given directions to file an open records request, and then the video no longer exists. This is one of the pitfalls of representing yourself. I try and tell people in every arraignment, I tell people I give them essentially the Ferrata warning, like there's going to be some difficulty getting information into the record of the court or understanding the procedures of the court when you represent yourself. And it's not supposed to be impediments to it. You're supposed to freely be able to do it, but everybody knows that practically there are impediments to representing yourself. So at this point, the motion for new trial is denied. Mr. Okafor, also, you have SSD amounts pending. You have a balance of $491 due on your suspended sentence. So please continue to make those payments.
Your Honor, Mr. Okafor is not financially able. Is there something the court could maybe amend his sentence and that it would be more suitable for his economic condition?
Mr. Toombs, the fact that you're standing in my courtroom representing him tells me that he got some economic situation going on, because that fine fancy suit don't buy itself. So, sir, I'm just saying, if he brought you into court as opposed to the indigent defense counsel, that belies the fact that he can't afford to pay his fines and fees.
Well, Judge, this first thing, this old suit. I had this suit.
You make it look good, Mr. Toombs.
Yeah, I usually try to take care of my things.
But yeah, Mr. Okafor, you have private counsel, so that right there tells me that you're not indigent to the extent where I have to relieve you of your fines and fees, sir. Now, it's due. It was due April 26th of 2024. You're facing an arrest warrant if you don't pay it soon. So tell me, what is the impediment to you making your payments?
Did you understand? No. What problem are you having making the payments? Did you tell him? Do you understand that? He doesn't understand that. He speaks very little English.
Mr. Okafor, why can't you make your payments?
Because I came to this, I stopped as I was supposed to stop on the side. I want the court to see the video.
Okay, no, we're past that. There's the video. There's no more video. So you owe $591. You've paid $100. You have $491 due, sir. And do you want to pay it? Not, you can pay it now. You can, but you're facing an arrest warrant if you don't pay it soon.
Hello.
So you're telling me, Mr. Toombs, that Mr. Okafor decided he doesn't speak English very well, but he decided to represent himself, because I don't recall him having problems with English when he represented himself. And he is now telling you that he can't afford to pay his fines and fees, but he can afford to have you represent him in court on a motion for new trial on a case where he represented himself, but now he can't speak English or understand me?
Well, no, I wasn't saying he can't speak English. I said he didn't understand what you were saying, the legal effect of what you were saying.
Okay, so the motion for new trial is denied. Mr. Okafor, you need to pay the $491 or else you're going to go to jail.
Could you give me some additional time, Judge?
I can. You know what, Ms. Powell, if you will give me a modification for Mr. Okafor, you can give him 2 weeks to pay the fines and fees in total so he can avoid an arrest warrant being issued. But we'll go ahead and get that to you. Just stay where you are and we'll get that signed and sent.
What about 30 days, Judge?
30 days, Mr. Toombs.
Oh, 30 days, not that long.
Mr. Toombs, based on the fact that, you know, you've known me since I was a baby lawyer, I'm gonna go ahead and give him 30 days.
Thank you. Thank you,
Yes,
Judge.
ma'am.
All right, so Miss Powell's gonna get that done. Once I sign it, I'll send it to the clerk's office and he can get a copy of it there.
Thank you.
All right, so just hang out in court until I tell you it's ready.
Okay, thank you very much.
All right, thank you. All right, on Palmer, Joshua Jelani Palmer, that's Scott Smith. This is closed. A case closed, and it was a motion to suppress, so that's done.
Also, Judge, this case was actually transferred to Superior Court on August the 9th of 2024.
Oh, okay, so that's the one that was transferred.
Yes, Your Honor, this
Thank
one.
you.
You're welcome.
So we closed it with us. Okay, so Ms. Hagler, let me go ahead. I've gotten to the bottom of the calendar. You can go ahead and begin speaking to the attorneys who are waiting to speak with you. And then I guess we'll determine if we have any motions going forward once you all have your conversation.
Judge.
All right, thank you. Just mute the courtroom for me.
All right. Thank you, Judge.
Thank you.
One thing,
Yes.
I want to
Hey,
introduce Mr.
Hi, Judge.
Lynch again.
you introduce him. He's who I started
I
with.
know you know him, John.
I'm gonna
What you doing, sir? How you doing?
I'm doing great. I'm gonna be joining Mr. Taylor in your courtroom if you'll have me.
Welcome back to Team Hayward.
Thank you, Judge.
All right. All right, so y'all mute and take care of business.
Thank you, Judge.
Thank you.
Judge Hayward, good morning.
Good morning.
Hi, my name is Dawid Israel. I'm here for Andy Amir Jairam.
Yeah.
I believe the prosecutor asked for a pretrial. Am I free to go or do I need to stay?
Hold on just for a second, because once they pre-try, that'll tell me whether we're going to go forward with a hearing. So she'll let me know whether the hearing is going to go forward, and then she'll be able to tell you whether you can leave or not, because you're not my witness. I don't control whether you need to be here or not, but I do know that they're talking about whether we need to have a hearing. And if we have a hearing, you'll probably need to be here.
Okay.
All right, but thank you, and just mute your device, and then you'll hear us when it's time to come back. All right.
Okay. Leave. What? It's time for us to leave, 11:05, man.
We're coming.
Ladies and gentlemen, two things. One, the attorneys are speaking with the state in the courtroom, so we're on hold for right now until we can make sure that we're not going forward on those hearings from the 10 o'clock calendar. And the second thing is, please make sure that your first and last name are on the calendar, on the screen. I see iPhone, I see single names, no first and last name, but I need your first and last name on the screen so that I'll know how to place you when it's time for a hearing or when it's time to help you. So please, if you would go to, if you touch the screen next to your name, you should see a blue box with 3 white dots in it. Click on that and it should allow you to rename. If you don't have that, then go to participants on your screen. It may be at the bottom of your screen. It may be on the side of your screen. Go to participants, click next to your name in a box that says more, and it should allow you to rename. So please rename yourself to put your first and last name on the calendar.
Your Honor, thank you for your patience. Whenever you're ready, I'm ready to proceed.
I'm ready. Okay, so we had breakout rooms for Archie, Jerem, and Johnson. So do we have announcements on those cases?
Yes, Your Honor. Regarding the first case, last name Archie, I did speak to the defense attorney. The defendant actually has 3 cases. We're going to resolve all 3 today. We're not going to move forward with any motions to revoke bond, but we're going to handle all those cases today through a negotiated plea.
Okay, are all of them related to DUI?
One is, the other 2, one is a public drunkenness, and then the other one is speeding, so traffic.
Okay, so I hope treatment is wrapped up in this and AA meetings, because that sounds like a problem.
We do have alcohol or drug use reduction, but I can add the AA meeting. Okay. Thank you, Judge.
All right, so are y'all ready to go forward now, or you need a moment?
Nope, we're ready.
All right, so Miss Kiera Simone Archie, come forward. All right, Miss Archie, unmute the computer in the courtroom for me, please, Deputy.
Thank you.
All right.
Apologies, I
Thank
didn't
you.
realize we were muted.
All right, so Miss Archie, how old are you?
I'm 32.
Okay, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. You're before the court on 2022 CR 06616. Kiera Simone Archie, represented by Attorney Julie Kurt. You're before the court for DUI count 1, DUI less safe count 2, striking a fixed object count 3, too fast for conditions count 4, an improper lane change count 5. That's just on the first case. Miss Hagar, could you tell me the second and third cases for please?
Yes, Your Honor. The second case, case number 2022 CR 01063. And there are actually 3 counts. The first count is speeding, going 11 to 15 miles per hour over. The second count is obstruction. And then the third count is a seatbelt violation.
Okay.
And for case, yes, Your Honor, the final case is 2024 CR 02121.
Okay.
And it's one count of public drunkenness.
All right. So, ma'am, you're before the court on each of these cases on the cases case 2022 CR 06616, also case 2022 CR 01063, and case 2024 CR 02121. So, Ms. Kurt, do you intend to, I guess, resolve all of these cases today through a plea?
Correct, Judge. We have a negotiation with the state.
All right, so for the first case, what is your client plea to the offenses before the court? DUI count 1, DUI save count 2, striking a fixed object count 3, too fast for conditions count 4, and improper lane change count 5.
My understanding through the negotiation with the state judge is that she's pleading to count 1. The remaining charges will be dismissed and merged.
That is correct.
All right. All right, and as for case 2022 CR 01063, speeding, obstruction, and seatbelt violation.
Your Honor, in exchange for the defendant's plea, the state is actually going to non-pros that case. And we're also going to non-pros the case ending in 02121 as well.
Okay. All right. By entering a plea of guilty on the case 2022 CR 06616, count 1. Count 2 will merge. Counts 3, 4, and 5 will be no pros. On the remaining cases 2022 CR 01063 will be no pros, and 2024 CR 02121 will be no pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Ms. Archie?
Yes.
All right. Factual basis and recommendation, please.
Yes, Your Honor. On or about June 8th of 2022, Your Honor, the defendant did receive citations for driving while under the influence of alcohol. She also received a citation for striking a fixed object, and as well as a citation for improper lane change and driving too fast for conditions. Your Honor, at this time, the state's recommendation or offer is going to be 12 months to serve 2 days, balance probated, a fine of $600, 240 hours of community service for the defendant to complete DUI, alcohol, or drug use risk reduction program, to also undergo substance abuse evaluation, and to follow any and all recommendations for treatment, and to also attend Alcohol Anonymous meetings. And again, the state is going to not prosecute counts 2, 3, 4, and 5.
All right. Ms. Kurt, anything on behalf of Ms. Archie, particularly about why somebody would pick up 3 charges in a short amount of time, knowing they already had one, and it was a violation of her bond to get a subsequent charge, but she did it twice? What's going on? Because it sounds like either trauma or grief or something's going on with Ms. Archie.
It's a combination of those, Judge. A couple things. These all did happen sort of in short time of each other. She was undergoing an abusive marriage and that has now been resolved with a divorce judge. She is currently a single mother to her 5-year-old daughter. In addition, the public intoxication charge came on the night of her grandmother's death, Judge. There was no driving involved on that particular incident, but I did provide the state with a copy of the funeral notice for that incident, Judge. She has been proactive in this situation, Judge. She's looking to turn this situation around. She's already completed a drug and alcohol evaluation, started on her community service, Judge, and has completed DUI school. I think she's looking forward to focusing on raising her daughter and not engaging in this type of behavior further.
So Ms. Archie, usually, like I said, I look for patterns, and usually when I see this, I've been doing this long enough to know that something's going on. If a seemingly law-abiding citizen has a string of offenses in a short amount of time, and Ms. Kurt has provided more than adequate explanation for what's been going on. I applaud you for your courage, for ending a marriage that was not working for you, that was in fact detrimental to your stability and health. So that takes a lot of courage. But you have to find a way to cope with life's difficulties in a way that does not put you at risk for being away from your child, either through jail or through, you know, something happening to you because you're not able to protect yourself or look out for yourself because you're under the influence of alcohol, because she needs you. Okay.
Yes,
all right. So I applaud you also being proactive. You know, initially I was like, oh, we know processing a lot of stuff, but now I see that you've done some of the work necessary to move forward, and I appreciate that. So I'm going to accept your plea of guilty to count 1. Count 2 will merge. Counts 3, 4, and 5 will be no pros. On count 1, 12 months to serve 2 days. It is my understanding you've already served that 2 days. Is that correct?
Correct, Judge. She did an arrest.
All right, credit for time served. The balance will be probated for you to pay a fine in the amount of $600. It's gonna be more like almost $900 with the surcharges. I haven't memorized that one, I'm sorry. 240 hours of community service. Please find someplace where you're gonna be able to be consistent with the community service. I know Hosea Helps has expanded their approach. So they used to just be in City of Atlanta, but I think they're everywhere now. And there are all kinds of organizations, food banks, animal shelters that need you. So please find somebody where you can be of assistance. You'll take a DUI risk reduction course, which you've already done. If you've done that, present it, the proof of that to your probation officer at your first meeting. Substance abuse evaluation and any treatment that they may order. Also present that at your first meeting. You'll do one AA meeting a week for the first 6 months, okay?
Thank you, Judge.
All right. And then you'll just show proof of having attended the AA meeting. You're to have no alcohol or drugs during the course of your probation, any illicit drugs. And then you're subject to random screens for alcohol or drugs, okay?
Thank you, Judge.
All right, Miss Archie. You've been very proactive in moving forward, and I wish you well. And I hope that things continue on the upswing for you. Okay. What you gonna? Yes, ma'am.
Oh, sorry. I was just gonna ask where we wait for probation.
Oh, I was going to tell you, once you leave the courtroom, you're going to go to your right. You'll go down to the next courtroom, courtroom 305. In the second, I think when you come through the first set of double doors, in one of those rooms on the side will be Miss James, who is the probation expert, and she's going to do your intake. Ask any questions that you might have that, like if you have issues with transportation, if you have a job that is non-traditional, all of those things, ask those questions and she'll assist you with that information, okay?
Thank you.
All right.
Very much for your consideration today. May I be excused?
Yes, ma'am. Thank you so much.
Thank you so much. Thank you, Madam Solicitor.
I see your foot has healed.
Yeah, yes, I'm on 2 feet for now. We'll see. I'm clumsy. Anything can happen. Stand by. Thank you.
All
Judge.
right. Take care.
Thank you, Judge.
All right, so we've taken care of all of Miss Archie's cases. That worked out. Barnett is a withdrawal. Paul, that case is going to be continued probably to pretrial. Now, Jerem.
Ron, the state's going to now process that case, and you should have that document for your review and signature soon.
All right, let me check that. Okay, Jerem will be no pros. All right, so Mr. Dalton, you and your client are free to go on that one.
Thank you very much, Your Honor.
All right, thank you, sir. Thank you, Mr. Jerem. And Mr. Jerem, there was a witness for Jerem. So Ms. Hagler, if you want to release that person, you may.
Yes, Officer Yajreel, you are free to go. Thank you, sir.
Thank you. Y'all have a good day.
Yeah,
Thank
so
you.
anyone here on Archie or Jerem, you're free to go at this time.
Thank you, Judge.
And then Johnson.
Thank you, Judge. We're withdrawing our motion on Mr. Johnson.
All right, that motion will be withdrawn. And Miles is withdrawn. Okafor, motion was denied. And Smith, that's a transfer. And that motion, that case was denied, it was closed here. All right, so let's see, what is our next calendar?
I'm sorry, what does withdraw mean?
It means that that motion is not going to go forward, that either there is no reason to continue with the motion or something else has been determined between the attorneys, okay?
Mr. Miles, this is.
I'm sorry, my phone's going out, but my name's Miles. I was just trying to figure out what was the information on me.
Okay, so what I'm going to ask you to do is we're going to be in hearings for the rest of the day, but if you will call Mr. Taylor in the morning, and then he can explain to you what happened.
How can I get that information or number?
For Mr. Taylor's office?
Mr. Miles, I will chat it.
Yes, ma'am.
In the chat window now. Okay,
He's gonna put it in the chat window, so don't log off, just, and make sure you write it down once you see it, because once we close out or once you log off, that won't be available to you anymore, okay?
Yes, ma'am. Okay, thank you guys.
All right, thank you.
All right.
All right, on the criminal motions calendar for 11 a.m., I'll call those cases. Lazarius Black.
Your Honor, the defense attorney has filed a motion to withdraw.
All right, so Black is withdrawn. Anyone here on that case, you're free to go at this time if you don't have anything else before the court. Emily Brown, that case is closed.
Yes, Your Honor, it appears that the defendant filed a motion to seal pro se. I'm not sure if the defendant is on, but if not, we ask that you deny the motion.
Your Honor,
Yes.
the defendant's in the courtroom.
Oh, okay. Tony Brown, come on up. Let's see what this motion to seal is about.
Right here. And just,
Good morning, Your Honor.
Hi, move over this way a little bit for me. Okay, so you're asking that your failure to yield case be sealed. Tell me why you're requesting that.
It's actually still showing up on my record. I pleaded nolo, I paid the fine. It was 17 years ago, but I recently had a background check run for a job, and it's still showing up on my record.
Okay, did they not deny you for a failure to yield?
They just said, pay the fine. I paid the ticket, and that was it.
Okay, I get it, but what I'm saying is your record is not automatically expunged. If you plead nolo, that's something that's going to show up on your record. Now, I don't know who goes back 17 years, but if it would still be there, because it wasn't, a nolo doesn't mean it's going to be removed from your record. It just means that you have not admitted anything, that you just resolved the case.
So what should I do to get that off my record? Because like I said, it's still showing up, and I have the paperwork to prove it.
Okay, I don't doubt that it's showing up, but is it a detriment to you from getting a job or anything else?
I mean, it potentially can be. I'm a paralegal. So I don't know if at some point in time it could eventually have an effect.
Ma'am, I'm a judge, and I got speeding tickets and all kind of stuff on my record. Yeah, that's not gonna hurt you. But if you wanted, the state is there's a procedure. Yes.
Your Honor, we actually we having a record restriction fair October 5th. And so
Man, what I was just about to say it, Mr. Brooks. I said, so yeah, I just didn't know the date, but thank you for reminding me.
The application is online actually, and so if she goes to our website, she should be able to find the application online.
Okay, so what you're looking for is Clayton County Solicitor General.
Okay.
Or if you can't remember that, just Google Charles Brooks.
It's
Charles A. Brooks, but
ClaytonSolicitor.com.
Yeah, ClaytonSolicitor.com.
Okay.
And then when you do that, they're gonna have the information about the record restriction fair, and you need to register, because it's free, but you need to register to make sure that they can accommodate everybody who's trying to come.
Okay, great. Thank you.
You're welcome.
Have a great day.
You too. All right, and LaTroya Quinice Davis. LaTroya Quinice Davis.
Your Honor, will state after you deny the defendant's motion.
Okay, I see her. She's online, but I can't hear her. Ms. Davis, can you unmute for me? Ms. Davis, do you know how to unmute? Can you hear me? If you can hear me, raise your hand.
Your Honor, I don't see a Davis on unless I see iPhone. Everybody else has their name.
No, I see her. She's in the corner. Yeah, I see her. Yeah, I do see the iPhone. I don't know why that person hasn't changed their name, but I do see Ms. Davis. She's frozen.
Okay.
No, Israel, we may still need you. So, if they're gonna pre-try, if the case has already been resolved, then, you're free to go, but until it's resolved, we'll need you. Okay, I don't know where she went. All right, so, Miss Davis, maybe she dismissed. I don't think hers is one that I can restrict, but she may need to go to the fair, the record restriction event, because I don't think that that's one where we can restrict it.
That is correct. Pursuant to the rule, that is one that cannot be.
Yeah.
Yes, Your Honor.
So, so that'll be denied, and she'll be back on in a minute, I guess, once she can get on. So Marquist Evans.
Your Honor, the attorney has filed a motion to withdraw on August 7th of 2024.
Okay. All right, Henry Polino Freeland.
Your Honor, that Attorney Jones, did file a motion to withdraw as well. And also this defendant has been accepted into pretrial diversion.
Okay. All right, so once they have completed, then we'll go ahead and resolve that case. And Samuel Hammonds.
Well, this is another motion to seal pro se. I don't.
All right, I see Mr. Hammonds. Mr. Hammonds, talk to me. What's going on?
Good morning, Your Honor.
Good morning.
Hope you're having a prosperous day today.
All right, so you're filing a motion to seal, but the case was no prost, so it's possible. Is the state objecting to the motion to seal?
Your Honor, no. No.
All right. So Mr. Hammonds, we'll go ahead and grant that motion, and we'll sign the order and send it down to the clerk's office. It might take a couple of days, maybe a week or so, because they have a process by which they seal it, but the online process can take a little bit longer.
Yes, sir.
All right. All right. So we'll go ahead and get that done for you. Thank you.
Thank you very much.
Take care, Mr. Hammonds. Tiffany Leanne Prater.
Thank you, Your Honor. Ms. Prater's here with me in the courtroom. We've pre-tried this with Attorney Hagler, and I believe the state's consenting to our request to modify the bond so that Ms. Prater can return to her home, and also to have contact with daughter and mother. No violent or harassing contact with her.
That is correct, Your Honor. And also for the court's information, Ms. Jordan Padron and Ms. Karen Prather are also present online. They're the victims in the case.
Okay. So does she live with them, or is she just trying to?
Yes, you can speak.
Oh, good morning, Your Honor.
Good morning.
No, my mother and brother, they live in Winder. I lived in Jonesboro at the time of this incident. And after I bonded out, I was told I couldn't return to my home address or have any contact with my mother or my oldest daughter, Desiree Prater.
Okay. All right. Y'all, so no violent or harassing contact has been modified?
That's our request.
All right, so Ms. Prater, I just ask that you be mindful of your bond conditions until your case is resolved. Even though they're being modified, be mindful of the modified bond conditions so that you don't have any issues with respect to picking up another charge or violating those bond conditions. Because if you were to violate your bond conditions, it's possible that you could be arrested and spend the remaining time in jail until your case is resolved. You could also be charged with additional charges, including misdemeanors and felonies. And you could also Yeah, I think that, yeah, you could have your bond revoked, you could have additional charges of felonies and misdemeanors. So you understand all of those things?
Yes, Your Honor.
All right, so just make sure you read it, get the paperwork, that once Mr. Taylor completes it and it's signed and everything, get the paperwork and be mindful of what it says, because most people, they just get their bond conditions and they pay no attention to them, okay?
I paid
Your Honor.
attention. That's why I'm here today.
Yeah,
All
she-
right,
About not
so,
resident, so that's.
So I can't.
Okay.
Your Honor, I,
My residence?
no, whatever they have agreed to, I'm fine with. But just make sure that you read it and adhere to what it says.
Yes, Your Honor.
and Your Honor, if I
Yes, Ms.
may,
Taylor.
so the bond condition that's being modified, it was to stay away or no contact. So we're going to modify that to no violent or harassing contact with the victims. And we're also going to add that the defendant needs to complete the family violence intervention program as well, as far as the bond conditions. Since we're
Okay, well, that'll put her ahead of the game with respect to the charges, so, all right. Just go ahead and send that to me, Mr. Taylor.
Yes, Your Honor.
All right, thank you. All right,
Yes.
Raymond Lamar Williams, yeah, Ms. Prater and Mr. Pedron, unless you have any objections to anything that was said, you're free to go at this time.
You all wish to speak, Ms. Prater or Mr. Patron, to the judge about the case, or?
I would just like to say, Tiffany's my daughter, and the evening of these incidents, you know, my granddaughter called me upset with her mother arguing, and I went down there to get my grandkid because I'm grandma and I'm going to come and intervene, and like I shouldn't. And I don't think that Tiffany is not a danger to anyone. I mean, they were having an argument, a family argument, and I went in, and I think me appearing made it a little bit worse, because then the kids thought, oh, well, here's grandma rescuing us, and, you know, they get a little sassy when grandma shows up, and I just feel like I should have minded my own business.
Well,
But that's what I have no fear of my daughter whatsoever.
Okay, well, I appreciate that. It's been modified, so it's no violent or harassing contact. So she'll have the ability to go back home, and then she won't have, you know, she won't have to worry about no contact. She can have contact.
Okay, thank you.
All right, thank you all.
Bye-bye.
All right, Raymond Lamar Williams. Mr. Brandon Rosenblum.
Yes, Your Honor. The defense counsel did indicate that he would be withdrawing the motion for withdrawing his motion for today.
Okay.
I'm not sure if he's on.
I don't think he is.
Okay.
Because usually I either see him or he speaks up. He's not.
Okay.
All right, so that concludes the criminal motions calendars for August 19th of 2024. We've resolved each of the cases. So if there's anyone here who has not, I guess, heard that their case has been resolved in one way or another, or their motion has been resolved in one way or another, or that they need some more information, just let me know. Mr. Evans, did you get the assistance you need? I can't hear you. You're muted, or you have no audio. I see you, gray suit, bow tie, blue shirt, but I can't hear you. So you may wish to log off, log back on, and choose computer audio or device audio. That usually helps. All right, Ms. Davis, did you have any questions?
Good morning, Judge. How are you?
I'm good. So, Ms. Davis, looking at your let's see. Wait, oh, sorry, I'm switched to the wrong calendar. All right, looking at your request, the nature of the charge that you have is one where I can't seal it because of the type of charge. Now, I don't know all the ins and outs of how these things work because that's not my area, but the solicitor's office is having a record restriction fair or event on I believe October 5th is what Mr. Brooks said. If you want to apply and go to see if there's anything that can be done, then you can do that through the Solicitor General's office. Just go on their website, Clayton County Solicitor General. Just go on their website and you can register for the event, but this is not one that I can seal.
I have a few questions. So I did complete the application and submitted it to the solicitor's office and it was denied. And
Okay.
so I filed an appeal and I was placed on a calendar to come in front of you.
Yep,
So
that's this calendar.
I'm confused as to, I guess, why the motion was denied. I think I heard the prosecutor state that the motion was denied.
The type of charge that you have is one that we cannot restrict.
Okay, so the process of having this restricted is not an option. Is that correct?
That from the statute does not allow restriction for this this type of charge. Yes.
Okay, and there will be no point in going to the event on October 5th?
Like I said, I can't restrict it via this means. I don't know if there being any way that I can do it. I don't know of anything else that the solicitors could do, but because I don't know the full range of possibilities, you can go if you want to, if they're having this event. But I know that this is not a charge that I can restrict or seal.
Okay, and then can you?
You'll be encouraged for it to apply anyway because Georgia Legal Aid will be there to assist in other remedies. Maybe she might be eligible for a retroactive first offender. It may be other options out there that may be able to help her.
See, so Mr. Brooks knows more about the other options that are available. There may be a way to do it where you go back and look at the original charge. I just know that I cannot restrict that charge as it stands now.
Okay, so contact the solicitor's office again.
Just go to their website and sign up for the event.
Okay.
Yeah.
Sounds good. So what's the website?
Oh, Mr. Brooks, what's the website again? I'm sorry.
ClaytonSolicitor.com.
It's confusing to me because the solicitor already denied the motion.
They didn't. Well, what you did, I guess you didn't hear Mr. Brooks. He said that there are other options that could be pursued through counsel, not through the solicitor's office, but there are other ways that it may be addressed as opposed to trying to get it sealed as it stands.
Okay, and then so the original charge, was that a no process agreement?
It was a what?
How did I plead to the original charge? Was it guilty?
I have that it appears that it was guilty on mine.
Okay, and then I'm sorry, what's the website again? I'm trying to write that down.
ClaytonSolicitor.com.
ClaytonSolicitor.com. Okay. And then once I go there, do you know, well, I guess the solicitor, once I go to this website, what's the next option that I will select?
There's the information about the restriction, the record restriction event. Just go ahead and register for it and then go to the event.
You'll see a couple of pages that have our social media handles. On the social media handles, you'll see a flyer that says Second Chance.
Second Chance.
There's a URL on there that you can click on that'll take you to the application process.
Now, the event for October 5th, is that in person?
It is.
Okay, I'll have to plan to do that, to attend that. Okay, is that also available on the website, the information?
Yes, ma'am. Just go to you'll see an area that has our social media handles. One is Facebook, the other is Instagram. On the Instagram and the Facebook, you'll see a flyer that says Second Chance Misdemeanor Record Restriction Ticket Amnesty Summit.
All right, sounds great. Thank you, Your Honor, and thank you, Mr.
All right.
Brooks.
Yes,
ma'am.
All right.
Leave the courtroom.
Yes, ma'am. Take care, Ms. Davis.
Thank you, ma'am. You as well. Have a good day.
Okay. All right. And Mr. Evans?
Yes, ma'am. Can you hear me now?
I do.
Thank you. I'm unsure as to where this lies. I spoke to my attorney this morning. He's never mentioned anything about a motion to withdraw. Last he said this morning, he was working on trying to speak with a solicitor. I mean, this has been going on over a year. All I did was walk through a door and call somebody a B. I mean, I just really want this.
Oh, hold on, Mr. Evans. I'm trying to figure out which calendar you're on.
Your Honor, page 2 of the 11 o'clock calendar.
Okay. Let's see. Sorry. Oh, all right. So Mr. Evans. All right. Yeah.
There's a note on the bottom of the calendar that says the motion.
Yeah, he withdrew it on August 7th of 2024. So you need to speak with Mr. Carnell.
So it was withdrawn?
Yes, sir. The motion for special and general demurs, that motion was withdrawn, yes.
So I don't have currently a court date scheduled for right now?
No, sir.
Okay. All right. I'll try to reach out to him. Thank you very much, ma'am. Have a great day.
You're welcome. Take care.
You as well.
Okay. All right. So that appears, that is, yes.
On that motion to modify, Mr. Taylor want to submit one thing, sorry.
I'm sorry, Ms. Terrell, I can't hear you, so it's kind of broken up. The motion to modify what now?
Motion to modify on Cracker is, Mr. Taylor want to submit that to bring us in. We're gonna draw.
Can you chat it to me? Because you're breaking up.
Okay, I'll chat to you.
All right, thank you. All right, so the next calendar is at 1 p.m. So we'll be back for that calendar. Everybody is excused until 1 p.m. And then I'm just gonna, Ms. Val, I'll give you a call. All right. Thank you all. Courtroom is down until 1. Mr. Okafor was waiting for the, I guess, the modification. Ms. Powell, did I get that? I'm looking on the, sorry.
Yes, ma'am. I emailed it to you. I can send it again.
Oh, nope, got it. Sorry. Okay. All right. So that's being sent back. Ms. Powell, if you will send that over to the clerk's office, to Ms. Castaneda and Ms. Wright, then Mr. Okafor, you can go down to the second floor to the traffic window, window and cashier, and they should have a copy of that order for you, okay? Thank you. All right. See you all at 1.
Yes, Judge.
Thank you.